transferring data. It is the fastest growing one of the fastest growing sectors of our economy. And for both the US and the EU, digitally enabled services, including the transfer of personal data, are more than half of their international trade in services. The US and the EU are each other's leading partners in trade in digitally enabled services, doing far more business with each other than they do with others, including China, for example. This makes the rules surrounding the international transfer of personal data an important element in a stable and growing global economy. For the last few years, however, data transfers from Europe to the United States have been under legal threat. The hallmark European privacy law, the General Data Protection Regulation, or GDPR, requires recipients of the data of EU residents to protect that data by taking certain measures, even if the data is transferred outside the US, outside of Europe, to the United States, India, or somewhere else. Concerns have been expressed that data transferred to the US might be caught up in bulk surveillance by our national security agencies. And twice, the European Court of Justice has ruled that the existing mechanisms to protect data transferred to the United States are insufficient. For the last 3 years, the US and the EU have been negotiating a new arrangement, a data privacy framework, which we will talk about today. But it's not just about the US and the EU. During the last few years, other arrangements seeking to govern the transfer of personal data have arisen around the world. We're going to talk about those as well and how they may intersect with the US-EU data privacy framework. A key question is, as increasing amounts of personal data move around the world, how can it be protected without creating multiple conflicting systems of governance? We have a great panel to discuss this. First, we have Lucrecia Buza from the European Commission. She is on the cabinet or private staff of Commissioner for Justice Didier Reynders, along with working on data transfers, including on the new US-EU data privacy framework. She covers artificial intelligence, competition policy, and values and transparency initiatives. She has extensive experience working on European competition and digital policy. She is joined by Stephen Lang, who is Deputy Assistant Secretary for International Information and Communications Policy in the new Bureau of Cyberspace and Digital Policy at the Department of State. Before taking this position in November 2022, he served as Minister Counselor for Economics at the US Embassy in Japan. And before that, worked on international communications policy at State for several years. He has served as a US diplomat in Mexico, China, Taiwan, Bangkok, and Havana. Third, we have my colleague Ken Propp, who is a non-resident senior fellow at the Atlantic Council's Europe Center and an adjunct professor of European Union law at Georgetown University Law Center and a senior fellow with the Cross-Border Data Forum. He is one of the leading non-governmental voices on issues surrounding data transfers and privacy. But from 2011 to 2015, he was legal counselor at the US mission to the EU, where he worked directly on many of these issues. Last week, the Atlantic Council released his most recent paper, More Than Adequate, New Directions in International Data Transfer Governance. So we're delighted to have Ken with us and the others as well. But let me start with Lucrecia. We have had an announcement earlier this week from the US Commerce Department regarding the US-EU negotiations for a data privacy framework, and it looks like things are finally coming to the culmination. Could you give us an update? And also, we know that the data privacy framework, as reported, has received some criticism in Europe, both from NGOs and from members of the European Parliament. How sustainable do you think the new framework will be? Are you expecting another legal challenge?
Thanks, and good morning, everyone. Here is the afternoon, but there, I guess, for most of you, it's still the morning. I should start by saying that, as usual, I'm speaking on my own capacity, so whatever I say cannot be attributed to either the Commissioner or the Commissioner I work for. And yes, just by way of explaining a bit our process and the most important steps, as you correctly said, we have presented a draft decision some time ago. It was, I think, already last year. This draft decision has been assessed by the European Data Protection Board, which is the European network of all the data protection authorities in the 28 member states. They have expressed an opinion on it. Also, the European Parliament has given an opinion. And after that, the procedure foresees that the text is submitted to the vote of the 28 member states. And after that, subject to the approval by the 28 member states, then the European Commission can adopt the decision. So we are on track with all of this procedure, and we hope to adopt the decision soon. As you mentioned, two important steps have happened this week also on the US side. These are, on the one hand, the fact that it has been explained that it has been announced, that the intelligence agencies have updated their guidelines to take into account the new requirements that are contained in the executive order that was adopted by President Biden last year. And then the second important step has been that the EU and the EAA, so the EU plus Liechtenstein, Switzerland, and Norway, have been recognized as, sorry, I should say Norway and Liechtenstein, they have been recognized as the qualifying states. That means that these are the states that can benefit of the new safeguards and of the new redress mechanism that has been created by the executive order of President Biden last year. So given these two steps are important for the entry into force also of the adequacy decision once this is adopted. Now, after a bit of an explanation on our side of the important steps, to reply to your question on the stability of the arrangement that we have put in place, we are very confident on our side that this arrangement is stable and meets the requirement of our European Court of Justice, which is the equivalent of the Supreme Court in the US. It's because it's the equivalent of the Supreme Court. The judgments are very important to us, and the latest judgment of the court that has annulled the privacy shield has constituted for us our mandate and the commissioner's mandate in the negotiations with his counterpart in the US. The most important requirements from the court related to the introduction of safeguards on the one hand, and on the other hand to the redress avenues for citizens, for European citizens. The new arrangement that we have put in place introduces important safeguards when it comes to the necessity and the proportionality of the data that is collected in the US. And what is important to say is that these safeguards are also concrete when it comes to the reasons why these data can be collected, because there are, and this is explained also in the executive order, there are a number of priorities for which these data can be collected, the conditions under which this can happen, the time for which these data can be retained, etc. What is important is that we tried to spell out in this new arrangement all to be as concrete as possible when it comes to the nature of the data that can be collected, to the seriousness of the threat, and also to the likely impact on the rights of individuals of the collection of the data. And for each of these important consideration, we have also given a concrete determinations of what that means. And also this will be subject to an oversight. In addition, we have created, there is the creation of a new data protection review court, which is substantially different from the previous system, which included the ombudsman. And the data protection review court is important because it facilitates access to redress to European citizens who can access this court in their own language. The procedure for accessing the court is also facilitated. And also what is important is the fact that the court is independent because it's constituted by judges that are appointed based on a slate, on a system that the judges fulfill certain criteria, and they cannot be removed without a just cause. Finally, this has also been important because it has created some misunderstanding. The judgments of these courts, decisions of the courts cannot be changed by any member of the executive bodies in the US. So all of these, we are confident, it strengthens a lot. On the one hand, the safeguards, on the other hand, the remedies. And this is why, whilst we cannot exclude that there will be, again, a challenge before the court, we are confident that this time the result will be a positive one.
So let me just press you on one thing, and that's the actual timing. If it's possible, businesses, every time I talk to someone about this in the business world, it's about how soon will this be done? We've had the announcement from the US this week. What's your thinking on the timing of the actual issuing of the final adequacy decision?
I can only say that it's going to be soon. I think it's being said already during this month. It's going to be soon this month. So I suggest you all stay tuned on this. You will not be disappointed.
Okay. All right. We will be watching. Let me turn now to Steve Lang, Deputy Assistant Secretary over at the Department of State. And although the US-EU arrangement has grabbed a lot of attention and headlines, it's not the only game in town. The US has been involved with other potential arrangements on data protection, such as the data free flows with trust and the Asia-Pacific cross-border privacy rules. Could you give us a picture of these other initiatives, these multilateral initiatives, and the approach of the Biden administration? And do you see these, how do they relate to the GDPR and the US-EU system? Are these alternatives to each other, or are they things that can be linked together somehow?
Yeah, thank you, Fran. And first of all, thank you very much for this opportunity to join such an esteemed panel and to talk about a really important subject. So I guess I would say that businesses have flagged for us many times that having more tools in the toolbox can assist in cross-border data transfers. We've counted that there are more than 150 data protection laws currently in force around the world, and no two of them are exactly the same. Regulatory divergence has contributed to digital trade restrictions that mean that no one tool could possibly address all the laws at the same time. So as a result, the United States has adopted an all-of-the-above approach that includes the use of the data protection framework for US-EU data transfers, following the appropriate adequacy determination by the European Commission, but also standard contractual clauses and model contractual clauses, as well as binding corporate rules. However, given the proliferation of data protection laws, we are particularly focused on promoting data transfer models and tools that promote interoperability among the data protection regimes around the world, and tools that are ultimately scalable, recognizing the variety of historical traditions, constitutional norms, and legal standards on data privacy and data governance around the world. We believe the Cross-Border Privacy Rules Forum, or CBPRs, represents a great example of this approach. The CBPR system is a government-recognized data privacy certification system that companies can use to certify their global operations to internationally recognized data privacy standards. Requirements are based on core data privacy principles that were first recognized internationally in the 1980s and revised in the 2013 OECD privacy guidelines. And these core principles are reflected in data privacy regimes around the world. Currently, there are 9 economies that participate in the CBPR system as full members: the United States, Canada, Mexico, Japan, the Republic of Korea, Singapore, Australia, Chinese Taipei, and the Philippines, supporting $4.4 trillion in trade and investment between the United States and these economies. And we are very happy that the United Kingdom has also applied for associate member status, and we hope that they will be admitted very soon.
Great, thanks very much. Let me just follow up and say, do you see how this might intersect at all with GDPR? I'm going to ask Lucretia that in a few minutes, but I'm wondering how the US government is seeing this as they get ready to sign this finalize the data protection framework.
Yeah, I think that we really see these tools as complementary. We feel there's a need for more than one option, given the vast variety in different approaches around the world that are informed by different histories, backgrounds, and perspectives.
Great, thank you very much. Let me turn now to Ken Propp. And Ken, first, congratulations on the paper. I think for all our listeners out there, our viewers out there, it's a very clear explanation of the current situation and of these many other initiatives that Steve was just discussing. I'd like to focus, though, for a minute on the US-EU part of this, and then we're going to expand the discussion more on the multilateral side. What is your view, having gone through some of the earlier, having personally gone through some of the earlier iterations of US-EU data privacy arrangements, of the sustainability of this particular framework that's being put forward? And what other avenues do the US and the EU have to build some kind of a data protection arrangement should this not prove to be sustainable?
Thank you, Fran. It's great to have this opportunity this morning with such distinguished colleagues from the US government and Brussels. Lucretia has outlined the key aspects of the new framework. It's very likely that there will be a challenge before the Court of Justice, and the focus will be on these twin aspects: one, necessity and proportionality of US foreign surveillance collection, and two, oversight and redress for individuals if they feel themselves to have been mistreated. On necessity and proportionality, it's significant. For the first time, the US has actually agreed to the European vocabulary of necessity and proportionality. They've indicated that it will be interpreted according to US legal traditions, but if you look at the agreement itself, you see that the concepts are very well fleshed out. There are, for example, lists of legitimate objectives for intelligence collection, as well as ones that are prohibited. One question that certainly will arise before the Court of Justice has to do with what's called bulk collection. The framework forthrightly says that bulk collection is not prohibited, but the European jurisprudence on bulk collection has become quite restrictive. So I think that's an issue for the court. The other one, and this was really quite a legal puzzle to sort out, was how to strengthen oversight and redress mechanisms. And the US took a number of significant steps here. There's strengthened oversight through the intelligence community itself. There's involvement of the Privacy and Civil Liberties Oversight Board, which is an independent federal agency, not part of the intelligence community. And then finally, and most notably, the creation of a data protection review court under authority of a regulation issued by the Department of Justice. Now, one can find aspects of the structure on redress that are different from how some European countries structure it. Notably, it was created by an executive action rather than by a statute. It's technically an administrative tribunal, even though it's called a court. And there's nothing said in the data privacy framework about the possibility of appeal to a traditional judicial body. That doesn't mean it's excluded, but it's not specifically specified. My initial assessment is that this agreement stands a better chance of being sustained by the Court of Justice than its two predecessors. I think if the court looks at the framework on a holistic basis, rather than looking for something that exactly mirrors EU laws and practice, that there is a strong basis here. And of course, the standard is essential equivalence. It's not identity. At the same time, it's completely conceivable that the court could again find that the U.S. has not met court standards, fundamental rights standards, for the reasons I've outlined. The court has a tradition of activism in this area, and it clearly sees fundamental rights as one of its signature topics. So I think this is a TBD question in the end. Your second question was what else U.S. and the EU might do bilaterally, and it might seem perverse, ungrateful to be suggesting that they should do more when this extensive labor over several years on the new data privacy framework is finally coming to fruition. But given the reality that the framework might not survive at the Court of Justice, I think it's important for Washington and Brussels to be thinking about other conversations that could be fruitful. And I suggest two in the report. One of them is engaging the Trade and Technology Council, and the second is perhaps having discussions in the context of a digital trade agreement. The data privacy framework was not negotiated in the TCC forum. That was a very conscious choice. It was an ongoing negotiation at the time, had a firm basis. And finally, the agencies involved, particularly on the EU side, are not necessarily the ones that are leaders in the TTC. So there's there were bureaucratic complexities there. But now, particularly now that the TTC has established itself as a useful forum for finding common policy ground, I think there are topics that could be brought in. For example, the TTC has done really solid work on assessing risks relating to artificial intelligence. Why not take up the question of privacy risk, which is what underlies this whole conversation? And the second aspect of the TTC is that there is commonality between US and European privacy laws on the concept of accountability, building in rules for making companies responsible stewards for the data they collect and exploit. And I think that topic as well is one that could be fleshed out and developed further bilaterally, and then perhaps spun out into multilateral fora. The last point I'll make is about a digital trade agreement. There were extensive discussions on data flows in the context of the failed TTIP negotiations, Transatlantic Trade and Investment Partnership. There were significant areas of agreement. There were also some significant areas of disagreement on data in that negotiation. And it might be time to, as the U.S. starts to pursue standalone digital trade agreements with countries, other regions of the world, to go back to this conversation with the EU.
Excellent. Some interesting options there. And I'm going to turn to Lucretia for her reaction, particularly on the TTC and the need to keep talking as we move forward, because if there is a challenge, a legal challenge, it will take some time to play out. But also, Lucretia, in thinking about these multilateral initiatives and how compatible they may or may not be with the EU system based on GDPR, one thing that those of us who have tracked this have learned is that GDPR, the EU system based on GDPR and granting adequacy to other countries, is a very unilateral system. It's a designation by the EU. It's not a negotiation necessarily. And it's a negotiation about how one is judged adequate. How do you see that intersecting with these multilateral initiatives? Are they something that could be compatible with GDPR? Is there some way to build, if not a uniform, a compatible governance system? But first, your reaction on some of the bilateral issues and then the multilateral.
Sorry, I was muted. I just was saying, maybe I would start from a consideration. And the consideration is digital trade is something that is very important. And indeed, data knows no border. It's an important part of all our economies. But data it contains important information about people as well. When we speak about personal data, we speak about who people are, what they think, their political opinions, their views, other important things. And for our democracies, it is important to protect the right to privacy and the right to data protection. This is why in Europe we have enshrined this right in our primary law charter, and then we decided at a later stage to have the GDPR. The European system is a system that is open, that it, unlike other countries when it comes to movement of data, they are more closed. Our system is open. It allows the data to move around across the world. What it really requires, it's a continuity of the protection when the data moves across the world. And this is done by, and I think Ken was explaining before, by a system that is about adequacy, that does not require that everyone has the same law. We don't want everyone to do a cut and paste of the GDPR, but that in effect, in substance, the different safeguards that the other countries have allow Europeans to have the same level of protection of their personal information. Given this is in our primary law and also in our legislation, it is something that is important for us, and it is important to respect the court case law. So we are of course open to discuss with the different countries the ways to best transfer the data, and to see whether one system offers this kind of protection, this adequate protection or not, based on their system. We are not imposing our system either, but we need to do so with the tools that are recognized in our legislation. So this means that if we want to have a very strong partnership where data can freely flow, then when it comes to personal data, this needs to be done in a trusted and safe way. so only in the ways that are foreseen by the GDPR. Then this does not preclude that we advance on other fronts across common principles across different jurisdictions, as long as these common principles recognize rights to individuals and are also backed up by strong enforcement system as well. What has been important also recently is the work that we've done, for instance, within the OECD, where the US has also contributed to identify ways to ensure that data is protected from governmental access. And this, we are at the level of principles. So when it comes to the level of principles, all of these other fora are very welcome. The discussion is welcome to make when it comes to the concrete transfer of data, this can be done only using the tools that are foreseen by the legislation. When it comes to DDC, it's certainly a tool. It's very useful for, as the previous speakers explained, the framework have been taken on purpose outside of this, precisely because if you want such a level of transfer of data, intense transfer of data, that can be done only with certain tools. I should also say that something that we have seen in our context is a convergence towards certain principles, towards certain models, and in this respect, the GDPR has been used as a model by many jurisdictions across the world. That means that this kind of protection is also being recognized valuable by different countries who have inspired themselves by by the GDPR rules, and that there's enforceable, practicable, and functioning. Even it is indeed a unilateral decision of the Union to allow the data of European citizens to be transferred outside of the Union. On the other hand, it's true that it comes at the end of the process, and the US has shown it very well when there is a discussion between the two that is aimed at ensuring that there is a commonality across the two systems, and that there is a common level of protection. And I also should say that in particular in the US, we also have a designation from the US side of the EEA side as a qualifying state. So that shows also the kind of discussion that is ongoing there as well.
Thank you very much for that. And I know that national security has been a key element in the way the EU has looked at this, the protection of data from national security elements, while also having adequacy arrangements with several countries that have very strong national security bureaucracies, such as Israel, for example. But I want to ask Steve how the US is seeing this link between these various multilateral initiatives and national security. How are we thinking about whether those are compatible with privacy protections? The other question for you, Stephen, is the US does not have a comprehensive privacy legislation right now. We have some legislation in the health sector, for example, and particular sectors of the economy. In dealing with these other multilateral arrangements, and the US as an actor, it's a diplomatic actor in negotiations on those and in fostering those, has this been a disadvantage at all, or is it not a relevant factor that we lack domestic comprehensive privacy legislation?
Thanks, Fran. I guess first on the the linkages between national security and protecting privacy. I think all I can say is that these are both important priorities that the United States takes very seriously, and we want to make sure that our multilateral arrangements are reinforcing both those priorities. And that's complicated sometimes, but that's what we get paid for. And in terms of data privacy, or the lack of a comprehensive U.S. data privacy law, I guess I would first say that we do have strong privacy protections in the United States based on our legal system. And the fact that we don't have a single comprehensive law does mean that sometimes it takes more work on our part as diplomats representing the United States, explaining our U.S. privacy framework. But I don't see it as a major disadvantage overall. Of course, I'll also add that the Biden administration does support efforts to pass a comprehensive data protection law in the United States. And we also see that states are acting to protect data with several bills introduced in state houses. We're hopeful. I think there's bipartisan support on this issue, and we're hopeful we see Congress getting closer every year to making progress on this issue.
Thank you. I want to also invite our audience to send questions. We look forward to getting a lot of those and to having some time after the next question to Ken for audience questions. So please send those in. Ken, in your paper, you have written a lot about the links between the US-EU arrangement and the multilateral system, these many initiatives that Steve has talked about. How do you see those models of governance working together? As I said at the outset, we have more and more data going everywhere around the world, personal data, and we don't want necessarily to have conflicting. We don't have to have uniform, but not necessarily conflicting modes of governance. What are you seeing as the opportunities, if you were to focus on a couple of key priorities to move forward? And what are the challenges that will be faced in creating any kind of arrangements?
The situation is ripe for multilateral initiatives. If one goes to meetings with senior privacy officials from governments around the world and companies, you hear a great level of frustration being expressed about how the US-EU discussion has dominated, has taken the air out of the room for 10 years now. And there's an urgent need on the part of other countries in the world and companies that send data across borders for systems that are less costly, less burdensome, and most importantly, less uncertain than the one we have had for recent years. The good news is that there has been a burst of regional initiatives responding to this desire. You touched on some of them. The OECD has privacy principles, and as Lucretia mentioned, specific principles on government access to data for security reasons, which is a significant development. Also in Europe, the Council of Europe, which has been a leader in binding conventions on privacy, is relevant. Some of the most interesting new developments have to do with other groupings, including the G7 and the former APEC cross-border data rules, which have now taken on a global task largely through U.S. initiative. So the issue brief offers kind of a first catalog and assessment of some of these initiatives. The G7 just endorsed the OECD as the venue for continuing work on data free flow with trust, this Japanese concept. And that may entail some further work on the government access principles as well. There are regular meetings of the data protection authorities now from G7 countries. The global CDPR, while historically it has had a limited impact among companies, the approach of going global with it gives it a chance at greater relevance going forward. So I guess what I would say is that there is growing global momentum in this area. It's encouraging to see that all these conversations have taken place. Honestly, nobody knows yet how they will fit together, which ones will become more significant. We're at an early stage, but I think it's primed for progress in the next few years.
Thank you for that. Lucretia, let me come back to you. And I have an audience question that's, I think, kind of technical here. If there is a challenge by the ECJ, will the framework, the new framework, remain in force during the judicial process? At what point does the framework not exist anymore, and we have to start negotiations over?
Normally it will, I mean, it remains in place until it's annulled by the court. So during as it was the case in the previous judgment, concerning the privacy shield, the privacy shield remained in force until and our adequacy decision remained in force until the court decision, the court judgment. What can happen is that there can be a request for an interim suspension. But in that case, as in other cases, it's up to the court to decide whether the conditions for such interim measures are granted or not. So normally, it should remain in place until the judgment, which, as I was saying before, we hope it's a positive one.
And we've been going now for 3 years without privacy shield in place, and we've kind of patched some things together. So it does work for a while, right?
It works for a while, but there are
there are limits.
There is, yes, there are some risks that are associated to that, and in particular, the court has made it clear that it is on the companies as well, in the absence of a valid adequacy decision, to see whether the legal system of the country to which they are sending data fulfills the requirement of the GDPR.
Right.
And the court itself had said that the US system, in the absence of the new modification introduced with the DPF, did not fulfill this system. It had asked for additional measures that the companies may have introduced for their business organization.
Okay, all right. And then I want to come back to you also on the national security question, because you do have adequacy agreements with other countries. And some of them, as I mentioned, like Israel, do have significant national security considerations, bureaucracies, however you want to put it. How has this been addressed in other negotiations, in other adequacy decisions, this concern about national security potentially, national security agencies potentially being able to harvest data, look at data over, in excess? Krisha?
So we have
Oh, Lucretia, we can't hear you.
Different,
well.
we have analyzed different systems in the different,
Go ahead.
Yeah. So we have assessed different countries with different national security system and indeed systems. And indeed, the problem of the interplay between the objective of protecting national security on the one hand and protecting privacy and data protection and the personal data, sorry, on the other, it's a common theme. We have it also within the union, and there are ways to find an equilibrium between these two objectives. And that's what we have done throughout these negotiations. The criteria that we have applied for the analysis of also of other countries with which we have adequacy decisions, which are like Japan, Korea, UK, Israel, and also others, are the same that the ones that we applied in the negotiations with the US. So, looking at the court judgments, we have looked at the safeguards in place and at the remedies avenues in place. All these systems are different because, as I was explaining before, we do not ask a copy and paste, but in a different way, they offer individuals an equivalent level of protection to the one that we have in Europe. At least this is our assessment. Now, just to say that many of these countries had to also introduce modifications in their legal systems to achieve this level of equivalence. And this was the case, if I'm not wrong, also for Japan, but it recently been the case also, you mentioned Israel as well. They have also introduced some changes in their system. Israel is part of these decisions that were adopted before the entry into force of the GDPR. So we are reviewing them, and because they were based on the previous legislation and directive, and we are reviewing them, and we should conclude the review soon.
Okay, all right. So there is a process of review that goes on after a while.
Yeah, indeed. I mean, in some cases, for instance, like in the UK decisions, we also have some sunset clauses. That means that if the system does not offer, if in our assessment, the system does not offer anymore this level of protection, that decision cannot be applied anymore.
Stephen Lang, we have a question from the audience for you. And this viewer mentions that you had said that it creates a little bit more work for US diplomats to talk about the privacy protections that we do have because it's not one comprehensive legislation. And this viewer would like you to unpack how you are handling these explanations so that we can better understand the system in the United States and how that would intersect with data sharing agreements.
Well, I think it depends on the context of the conversation, how we make that explanation. Of course, in a complex negotiation, like for the data privacy framework, we have experts on both sides who are already quite familiar with the systems in each other's countries. But often we are doing public messaging, and we have to talk about the various types of legal protections, and just how the US system works, that for instance, our health data is protected by one piece of law and other protections are enforced by the Federal Trade Commission, or the variety of different ways that our various personal information, types of personal information are protected. So there isn't like a single formula. It depends on the conversation. But it sometimes, it can take some time to help people understand that that there's more than one approach to protecting privacy.
No. Ken, let me turn to you, because in the paper, as you talk about the opportunities that are out there to move towards some of these multilateral initiatives, a couple of times you do kind of say, when the US has a comprehensive privacy legislation, or it would be easier if the US had. So what is your take on the importance of having privacy legislation if the US is going to be a leader in these particular initiatives? Will we be limited as long as we don't, or are Steve's explanations will they do the trick? So,
Well, Steve has put it politely. These are sometimes hard conversations, and I can say that from experience, having been involved in many of them for the State Department over the years. What is particularly striking is the symbolic role of the U.S. not having a national privacy law at a time when most other countries in the world do, including countries that the U.S. does not necessarily consider to be democratic countries, and that has an impact in multilateral settings because it's an easy argument to be used. Now, it's worth recalling though that even the privacy law that advanced in the U.S. Congress in the last session, and which may be back under discussion soon again, even that law does not address international transfers in any systematic way. So it's different from the GDPR in that respect. In fact, the only provisions in it that deal with international transfers are restrictive ones aimed at China. So, so there really is a sizable gap here. It plays out in numerous negotiating fora, including some binding ones. The UN, for example, is closing in on the evidence convention. That's exchange of information for criminal law purposes related to cybercrime. And the U.S. has a harder case to make because of the complexity of our protections. It's not that they don't exist, but they exist in sector-specific statutes and at the state level primarily.
so, and what is your prognosis? I mean, we're about to go into an election year here in the United States. What's your prognosis for whether we will get a privacy law? There have been some attempts up on the Hill.
Yeah, as we said earlier, I think we're closer than we've ever been. Whether that will translate into actual adoption in an election year, that's a much harder proposition. One other factor here is that the issue of artificial intelligence has come along and seized the attention, not just in the U.S. Congress, but in the U.S. populace generally. And there are significant privacy issues that are raised by artificial intelligence. So I think that legislation may be a vehicle for some of the privacy questions. The EU is also advancing its own AI legislation. So that's another important dynamic here.
So yes, exactly. And let me go to Lucretia for our last round here. We just have a few minutes, so I'm going to ask everyone to be kind of brief. But Lucretia, I think Ken makes an excellent point that AI, and especially the release of ChatGPT, has kind of raised the temperature on this and has raised more questions about privacy and artificial intelligence. When you look at the EU's approach, how do you see the intersection between the AI Act that's coming down the pike? We may have an agreement on that by the end of the year. GDPR. And is there a way to push that into the multilateral sphere? One of our readers, and I'll ask you each, one of our viewers, and I'll ask you each to say yes or no, is whether there is a way to talk about establishing a dedicated body that would deal with data transfers via digital platforms. So can we create a club, a data club? Or is that just too much to ask? So Lucretia, a couple of complicated questions for just a couple minutes answer: AI and privacy and a club.
Yeah, so AI Act and the GDPR, well, the AI Act is built on the GDPR. So it has the same approach, which is ensuring control of data, of personal data to the individual. when relevant, it refers to GDPR in many respects, and it builds up on some GDPR requirements as well.
Okay.
For brevity, I will not go too much into details, but just to say that the two systems have been worked together, also when it comes to the enforcement and the interplay between the data protection board, so the data protection authorities, and the AI, the authorities that will be responsible for the enforcement of the AI Act.
Okay.
And the other question on the...
Well, no, let me move on because we're about to
Yeah.
end, but I'll ask Steve if he sees, in working with these multilateral initiatives, is there, is it a time that's ripe to be talking about something else, whether it's an institution or an overall body, a dedicated body dealing with data flows that could kind of be, is that where the discussions on data-free flows with trust at the G7 might and OECD might lead to an actual body or institution rather than just agreements?
Well, our discussions on DFFT that came out of the G7, the U.S. was very supportive of Japan's interest in operationalizing DFFT, and the approach that we agreed to take is through an institutional arrangement partnership, an IAP, that could that we think the OECD would be well suited to host. So this will be some type of institutionalized partnership. I don't know, we don't know exactly what that will look like, but it will carry forward the conversation on data flows in a new framework that we want to be multi-stakeholder. So we will see how that develops.
Okay, good. And Ken, looking at this from outside, do you see hope in that direction, or is this going to be more of a bilateral versus multilateral arrangements that govern data flow?
Well, what you suggest is very ambitious, but one can see in many different settings that there is increasingly common thinking between the US and the EU, that allies have to stick together on data issues because they have national security implications. Some of that is due to the Ukraine war, but it's a new sense of urgency and working on these things together. So I think it's optimistic in that respect, and not to be excluded.
Well, thank you all very much. We've come to the end of our time. I think this was a super panel, and we're all going to be looking next week or very soon, as Lucretia puts it, for the final announcements about the new US-EU data privacy framework. But then we will also be watching for the evolution of these other multilateral initiatives and how they will intersect with each other as we strive to protect data around the world. So thank you very much to all of you for joining. Ken, congratulations again on the paper. Thank you all.
Thank you.
Thank you. Bye.
Bye.